Hello everyone, welcome back. I am Miss Sini and I'm an intern in LEXIS and Company. So the topic which we are going to cover today is regulation of content on digital platform. So let's get started. In the past 2 decades, the audiovisual field has undergone so many technological advances at a fast pace. The source of entertainment of moving pictures have moved from television to TV and currently to the internet. This is the medium of a huge impact of society which forms the basis of its regulation by the state. The changes in the medium that are used to distinguish audiovisual content and the changes in society are linked. Freedom of choice, portability and increased accessibility has inculcated few habits of content consumption and have changed the perception of people of time and space. Over-the-top OTT media services have revolutionized their television watching experience. OTT platform includes platforms such as Amazon Prime, Hotstar, Netflix. They also include subscription-based audio or video hosting services that are majorly involved in streaming featured films, web series, documentaries, etc. In India, this revolution has led to policy vacuum. India is a diverse country in terms of caste and religion, language, economic status, and issue of content regulation has always been important in India. Content regulation in India has given the shape by 3 key policy makers: the government, the industry and the court. The government of India by way of notification have brought OTT platform, film and audiovisual programs, current affair, news of online platform under the ambit of Ministry of Information and Broadcasting. So now let us see the current regulatory framework of OTT. In India, the content is regulated by the provision of Information Technology Act 2000, Indian Penal Code 1860. It is also regulated by special provision legislation such as Embils and Names Prevention of Improper Use Act 1950, Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989 and Indecent Representation of Women Prohibition Act 1986. An example is that OTT services providers has ensured that the content that is available in their platform is in the compliance with Section 367A, 67B and 67C of the Information Technology Act 2000. The above mentioned section provide for imprisonment and penalty of transmitting or publishing sexual exhibit material depicting child in sexual exhibit acts in electronic form or obscene material. No legislation exhibits specific to the over-the-top OTT industry, unlike the cinema and television industry. Cable Network Television Regulation Act 1995 and the rules laid down under it regulates television broadcasting in India. In 1994, rules laid down by Program Code which regulates the content on TV. According to this code, a program cannot be transmitted through cable services that contains any obscene, deliberate false and suggestive inducements or half-truth, is defamatory and against good taste or indecency, contains anything against maintenance of law and order, encourages superstition or blind belief, is likely to encourage or incite violence, which promotes anti-national attitude, etc. If an authorized officer, which includes the district magistrate, the commissioner of police, etc., discovers that the provision of the code has been violated, the officer has the power to seize the equipment of the offending cable operator. So now let us see the highlights of the new rules. The notification dated November 9th, 2020 has added 2 entries, 22A and 22B of the Government of India Allocation of Business Rule 1961. These 2 entries are film and audiovisual programs made available by online content providers, news and current affairs on the online platform. By this addition, online content in India is now regulated. This includes content from OTT platform, news platform, current affairs available online and social media platforms. The rationale behind this regulation is unregulated content that is made available online with no proper regulatory mechanism, with little to no scrutiny. The unregulated content of such platform while impact to viewers include minors. Also, there is a need for level playing field among other content providers. For example, first is television, both news and entertainment are being regulated by Cable Network Regulation Act 2015 respectively. Second is print media is regulated by the Press Council of India. Third is advertisement are regulated by the Advisory Standard Council of India. Fourth is news regulations were offered by the News Broadcaster Association NBA. And fifth is films are regulated by the Central Board of Film Organization CBFC. The online content was needed to be regulated to provide protective measures to its audience and to curb the freedom of content provider. Now let us see significance of social media intermediaries. Significant social media intermediaries SSMI is a new class of intermediate that have been introduced by the 2021 IT rules. SSMI means a social media intermediary have 5 million or more registered users in India. Intermediaries falling under this category have to adhere the additional compliances while discharging the duties. So these compliances are the following. Certain personnel have been appointed under 2021 IT rule by SSM, including first is Chief Complaints Officer. The Chief Complaints Officer will be responsible for complaints and he can also be held liable for contravention of 2021 IT rules. Second is Nodal Contact Person. The nodal contact person will be responsible for their 24/7 availability for coordination with law enforcement agency. Third is Resident Grief Officer. The Resident Grief Officer is in charge of the grievance redressal. This common person has to be a resident of India and SSMI. In order to receive the communication under 2021 IT rule are required to have a physical contact address. It mandates having local present officers or having a contact address in India at significant cost and legal risk. Extraterritorial jurisdiction is provided by IT Act and IT Rule 2021 made it easier for the court in India to exercise jurisdiction of intermediaries outside India. So now let us get into the conclusion. The content that is made available to more than 2 million users daily resonates with the nature of Indian society. It resonates with the term of caste, religion, economic status, society norm, behavior, language, caste, etc. Thus, it is an issue of content regulation is crucial and it is governed by how it affects society. There is a need for stakeholders and governments to come together, and in the fast-changing environment, media brings a proper framework and order to balance out the necessary restriction and freedom of expression for the sake of law and order. The creative freedom of content creators, makers can be influenced by the excise restriction and guidelines, which in turn will influence the viewership of OTT platform. The new age content makers by their content are breaking all the moral stereotypes, and digital media fate is under the hands of Ministry of Information and Broadcasting, which leaves little hope for the actors and the content makers. Through developing a legal framework for OTT regulation is still a work in progress. The government manner and extent of content censorship will decide its digital revolution fate. So I hope that this helped you to understand the new regulation in OTT platform. So we'll meet you in the next video. Till then, take care, stay safe. Bye.